you back to this afternoon's continuation of the 2008 Missouri Law Review Symposium, Return to Missouri versus Holland, a symposium on federalism and international law. We had a wonderful and some quite spirited sessions this morning, and we have still almost another full day ahead of us on this symposium, but this afternoon's lecture is the highlight of these annual symposia. We welcome you all here today. I want to particularly acknowledge and thank Judge Dwayne Benton, United States Court of Appeals to the 8th Circuit, and Judges Mary Rose Russell and Patricia Breckenridge. So we thank you for joining with us today in what will be truly an outstanding Nelson Lecture. The Earl F. Nelson Lecture was established by the trustees of the Law School Foundation in the 1950s in the memory of Earl F. Nelson. Back in 1927, so we're talking going back 80 years, Mr. Nelson saw the need for private giving to support an outstanding public law school. The Law School Foundation was as a result created, and its support has truly meant the margin of excellence for this law school ever since. Quite appropriately, it was the Law School Foundation that created today's lecture to honor Mr. Nelson and his vision for this school. As you can see from your program, our Nelson lecturers over the years have included some truly outstanding individuals, outstanding university presidents, deans, professors, 2 solicitors general, several justices from the United States Supreme Court, and just a few years ago, a winner of the Nobel Peace Prize. And we are thrilled here today to have our program presented by another truly distinguished Nelson lecturer, Professor Judith Resnik. Professor Judith Resnik is the Arthur Lyman Professor of Law at the Yale Law School. She graduated from Bryn Mawr College and NYU Law School, where she was an Arthur Garfield Hayes Fellow. While she now serves on the faculty at Yale, her other positions have involved either full-time or visiting professorships at the University of Southern California, NYU, Harvard, and the Universities of Toronto and Chicago. Professor Resnik's scholarship is both insightful and wide-ranging, and a small sampling of some of her most recent and notable articles are included in your program. In addition to her teaching and scholarship, Professor Resnik has been a leader both within legal education and the legal profession. She has chaired the sections on procedure, on federal courts, and women in legal education of the Association of American Law Schools. She is the founding director of the Arthur Lyman Public Interest Program and Fund at the Yale Law School. She's testified both before the United States Congress and the Canadian House of Commons, and she has argued in the United States Supreme Court. Her many honors include election to the American Academy of Arts and Sciences and the American Philosophical Society, and receipt of the Margaret Brent Award from the ABA's Commission on Women. We are truly honored to have Professor Judith Resnik with us here today as our 2008 Earl F. Nelson Lecturer to speak on the internationalization of American federalism. Would you please join me in welcoming Professor Judith Resnik to the Law School, to our symposium, and as our 2008 Earl F. Nelson Lecturer.
Thank you very much. Usually when I'm on the podium, I speak only for myself, but for those of you who are just coming at this point, I can tell you I'm speaking for everyone else who's gone before me in thanking Professor McInnes for convening a terrific set of sessions. We've all already learned a lot and are going to learn a lot more, and it's kind of magic that in the snowy winter we're all here more or less uneventfully, and very glad to be so. I'm delighted to have this occasion to share some of my thoughts with you, and in order to have us be on the same page, kind of literally, and as those of you who are students, I can't bear an opportunity to go by without giving you something to read. There's actually a handout that I'm going to be referring to as I'm talking. So if I think there are more, if everybody has one in hand, it's relevant. It won't be a PowerPoint that flashes on and off, but actually a piece of paper that's more or less transportable. Our shared focus all the day has been on the idea of the domestic and the international, and I'm going to start abroad, so to speak, for a moment by taking you to Europe and something that's at the top of the first page from Sweden. It's called the precautionary principle. The idea is credited to work in Germany, in the consumer and environmental area in the 1970s. It's now part of a fair number of European Parliament's legislation, both Europe itself and, as you can see, some countries. And it basically says, under a precautionary principle, that you should, whenever you can, take care not to do harm to human health and the environment. Now, at the U.S., at the national level, the typical understanding of how we think about this is something called risk assessment or risk analysis, that is a kind of utilitarian weighing of costs and benefits, but not San Francisco. In 2003, as you can see in the middle of your handout, San Francisco put into its local law, at the opening of its environmental code, something called the precautionary principle, making it local law and explaining it wants to do as little damage as possible to human health and the environment. Go back to Europe for a second. Under the precautionary principle, European regulators get worried in the late 1990s about a certain set of chemicals in cosmetics and in toys. They make things flexible, they make things smell, and they also may make us in various forms of physical injury, including risks of cancer and the like. So the European Parliament starts to put into place a ban on the use of these in toys for little kids and in cosmetics on our faces. Look at the bottom of page 1, banning toxic toys. Arnold Schwarzenegger, 2007, the state of California now says that any manufacturer cannot sell, distribute, or use in commerce any of a certain of these chemicals. This is the outgrowth of several years of work, and although the final bill doesn't mention the word Europe, one of the proposed bills actually had the list of prohibited substances key to those that the European Parliament and the Council of Europe themselves were banning. In short, I've just given you a first example of the foreign in the local. California has European law on toxic toys. Turn then to the next example. I'll take you again to the transnational scene, and yes, thank you, you're turning to page 2. We're in the Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW, for those of us who know it well. And it says that in all areas, political, social, economic, and cultural, we want to ensure the full development and advancement of women as principles of equality. More than 180 countries have ratified CEDAW. Jimmy Carter signs for the U.S. in 1980, but subsequent administrations find trouble in getting it ratified by the Senate. And the little snippet I gave you in the middle of the second page, Sovereigntist Opposition, gives you one of the points of views of one of our senators saying that to do so would be to surrender American domestic matters to the norm setting of the international community. Now, just as in the example of toxic toys, if you look only at the national level, precautionary principle versus risk analysis, you miss a lot of the action. By 2004, 44 U.S. cities, 18 counties, and 16 states had passed or considered resolutions related to CEDAW. Many of them are expressive, hortatory, U.S., please ratify. But a few of them actually incorporate CEDAW as local law, and I've given you a snippet of San Francisco again in 2003. It's what the European community, the United Nations, the Commonwealth Secretariat all call mainstreaming. Think about the implications of gender, whether it's parks or transportation or adult probation or wherever you are. Where are women and men, and how might we think about them in the story? Now, the conflict over how to deal with gender inequality in the United States is alive and well and engaged. In 1994, Senator Joseph Biden took up and encouraged he was actually the lead of a group of people who convinced the Congress to pass something called the Violence Against Women Act, or VAWA, I'll give you a lot of abbreviations. VAWA for these purposes. Congress said we've got interstate power, we've got 14th Amendment power, and we're going to enact legislation that funds anti-violence programs, funds shelters, create some ways to ease interstate agreements on enforcement of protective orders interstate. And we're also creating something new called the Civil Rights Remedy, modeled actually after some other civil rights legislation dealing with race, in which victims of violence can bring damage actions in the federal district courts suing their perpetrators. Statute enacted. Woman brings a lawsuit. She'd been raped at a college by two men, one of whom said in particularly disgusting language how much he liked to do such harm to women. But in the year 2000, the United States Supreme Court held in a case called United States versus Morrison, which has been referenced already today, that this was unconstitutional. Congress had exceeded its authority. It had, according to the Chief Justice, misunderstood. Violence was not, against women, was a non-economic criminal conduct that stepped beyond the congressional authority and onto the toes of the states. The majority reasoned that if Congress could do this, then maybe it could also do family law or other areas of so-called traditional state legislation, ignoring that, in fact, Congress does a ton of federal law of family. It's called immigration. It's called ERISA pension, which creates marital property rights. It's called tax, welfare, and a whole host of other provisions. The U.S. Supreme Court said, and I've just given you this tiny snippet, the Constitution requires a distinction between what is truly national and what is truly local. The bottom of the page, you can see that Senator Biden, undaunted, says, okay, I can't do it nationally, let's go global. So just a month or so ago, he introduces the International Violence Against Women Act of 2008, which in its text, if you look at that bottom of that page, women's political, economic, educational, social, cultural, civil, and human rights, boy, it sounds a lot like CEDAW, and it sounds something like San Francisco, because what he wants to do is gender mainstream into U.S. foreign policy ways to deal with violence against women around the globe, centralizing it in a national audience. I gave you kind of more of the bill because it's new and you might not see it, but the central point here is that he wants to create new money and new funding for new attention to violence against women in American foreign policy. Page 4, another example. Climate control, also already on the screen from this morning. Started in 1972. The conception is nation to nation. The Stockholm Declaration says, nations, you own your own resources, but please pay attention to things beyond your own borders. Go forward to Kyoto, in which in the late 1990s, a group of nations come together to say, let's deal with global warming. Once again, a president, this time William Clinton, signs on behalf of the United States, and once again, there's a great deal of opposition, and once again, the terms are sovereigntist. Here you've got the Committee to Preserve American Security and Sovereignty. Their wonderful acronym of COMPASS, giving us the direction of place on the globe, tells us that the Kyoto Protocol is a real threat. Politically unaccountable NGOs are going to harness the power of the executive, impinge on our national security. So just as in CEDAW, and just as now in Kyoto as well, from climate to human rights and equality, we hear a claim of sovereigntism. The national prerogatives are under assault. Now we're here in Missouri in honor of Missouri v. Holland, so it's easy to use this as the example of the point that, of course, in the U.S. history, it isn't only the nation that says the word sovereign, but rather states regularly. And in Missouri v. Holland, the little piece that I've given you from the Supreme Court opinion tells you that the claim by the state was that it threatened the sovereign rights of the states and countervened their authority. If you go actually to the transcript of the Supreme Court's of the appendix, you'll find in as several of the scholars of this also have adverted to, in the proceedings in the 1918s and 1919 in the lower courts, we hear that under the ancient law, the feudal law, the common law of England, the absolute control of wild game is an attribute of sovereignty. This is something that you cannot infringe upon. At the time, Chief Justice Holmes, Oliver Wendell Holmes, kind of agrees that it's obvious that taking care of migratory birds or dealing with wild animals inside the borders of the state is something up to the state to do. In the briefing, Missouri says, if you can do birds, what's next? Food might be next. Just the way that Chief Justice Rehnquist said, if you can do violence, maybe family is next. The slippery slope is before us. The concept that the environment belongs to the states is strong through the early 1970s. For those people who sit inside the jurisdictional rules of the Supreme Court and of the federal courts in general, there's a famous case about the original jurisdiction of the U.S. Supreme Court in 1971. Ohio brings a complaint saying that a series of chemical companies are polluting Lake Erie. There's mercury coming in, and they seek to invoke the original jurisdiction of the United States Supreme Court. At the time, the case sounds in state tort law. Ohio is seeking the abatement of something called a nuisance. The U.S. Supreme Court says, well, you know, problems of interstate air and water pollution, these are complex. Environmental blights, we really don't do that stuff. We're courts, they say. And over the dissent of the great environmentalist on the bench at the time, Justice Douglas, the Supreme Court says, go somewhere else, Ohio, to take care of this. Now, you don't have to go very fast forward in this story for that which once seemed to be quintessentially state, birds and mercury and water, to become, of course, federal, which is to say, in 1970, Nixon creates the Environmental Protection Agency. In the same decade, we have the National Environmental Protection Act, the Clean Air Act, the Endangered Species Act, the water. We got sushi, mercury problems. This last month, we have mercury in our sushi. What do we think? The feds better take care of this. And the environmental arena is so completely federalized that right now a bunch of car manufacturers are yelling at California, how dare you do gas emission control, excuse me, you're stepping on the federal toes for this purpose. So actually, somewhat ironically, Missouri versus Holland stands for this famous proposition that what the federal government could not do itself under its own powers, it can do through its treaty powers. The facts no longer support it because, of course, through interstate commerce, we imagine that the federal government can deal with the well-named migratory birds that are, in fact, we think, interstate as well as international. So what I've just done is showed you a bunch of categorizing, truly local, truly national, and watched people make claims about what is obviously and intrinsically one thing or another. And in the context of this, I've also shown you that there are many times when people say, no, no, that's domestic and that's foreign, and what's the purpose of these categories? Why are we in the category market here? Well, as the materials from the committee Compass on the security and sovereignty of the United States makes plain, we're talking about power and we're talking about power and process. The claim is that if you take something and take it into a category either called domestic or foreign or state or federal, you get some power over it. Now, how can you tell whether something is one thing or another? How do you know if California's ban on toxic toys or Missouri's effort to control bird hunting is or is not local or national or domestic or foreign? This effort at categorizing is what in feminist jurisprudence and other critical theories is called essentializing. It's as if it was sort of natural. You look at something and you know that's how women are. And this jurisdictional essentialism is what we're watching, as if it's just natural that something is exclusively is something that belongs. And of course, the point is that these are artifacts of human construction rather than artifacts of nature. What's the stake? The stake, of course, is about power. And the claim made by sovereigntists at both the state and at the national level is that to move something to another place is to take power from one place and put it illicitly in the other. And particularly in the United States, the claim is often made that if you go abroad, you're actually doing something that undermines American democratic majoritarian processes and undercutting federalism to boot, that you're really doing harm to us. And I gave you kind of a lot of the snippet from the Compass report because those claims are there in tail. So think for a moment what happens after Clinton signs Kyoto and then Compass says, please, this is a really stepping on and intruding on American political majoritarian federalist processes. Well, the White House switches hands, and then President George Bush withdraws support. In 2005, the Kyoto Protocol goes into effect with 141 countries ratifying it. We're off the story. But once again, look a nationalist to miss the action. because it turns out that mayors in Seattle and Salt Lake City say, we need this. And by March of '05, a group of 10 mayors agreed to their own climate control program. And I've given you just a little bit of the mayor's engagement, meeting Kyoto protocols. As of last fall, we had more than 700 mayors. We heard about Tulsa being number 500, representing between 65 million and 70 million people in the United States, all endorsing this program. So the people who wrote Compass, who said, this is really a problem for American politics, missed it. This was terrific for American politics. It proved to be a spur to a bunch of democratic iterations in which, through transparent and accountable processes, a whole bunch of politically elected officials said, we're on board for this. Now, what I've just done is put out a bunch of examples, and I need to pause to summarize some of the points that emerged from it. Point one, efforts to essentialize a certain kind of problem as intrinsically belonging to a particular level of government are doomed to fail. Most things are not either state or federal, local or national, but often both. Many, of course, the question of rape and global warming and toys in people's hands and birds partake of and concern people at many layers. Whether it's safe for me to walk across this quad is clearly a local problem, but it also entails national and international regimes and legal premises. Point two, transnational policy initiatives are not necessarily counter-majoritarian. To the extent sovereigntism is grounded in a view that it can sit nested inside American majoritarianism, it actually cannot demonstrate either a theoretical or practical nexus. Sometimes sovereigntists win, sometimes they lose. See the mayors. Point three, none of the examples I've given you, all of which are recent on purpose, are actually extraordinary in some way. I can give you local, transnational examples across the 20th century: Vietnam, Gulf War, Northern Ireland, Middle East, nuclear disarmament, protecting landmines, apartheid, restitution Holocaust, Iraq, genocide, sweatshops, gun control, etc. Given this, and I think it was already adverted to today in one of the other comments, one commentator says, unless America becomes a police state, municipal foreign policies are here to stay. They're deeply democratic in the sense that they're often the product of referenda by local majorities, popularly elected executive branch officials, city council members, taking positions accountable to their constituencies. Point four, opponents to the Kyoto Protocol, opponents to CEDAW, opponents to the precautionary principle are absolutely right to worry about transnational influences on America, on America's domestic policies. Of course they influence. Yes, absolutely. These are strong influences on local policies. And deep inside the local, one often can find these global influences. Sometimes they're actually expressed and cited. One of the versions of that California legislature said, see Europe. The mayors say, see Kyoto. Sometimes it's silent dialogues that are occurring in which people don't cite these things, but whether they're cited or not, the influences are there. Point five, I've been mostly talking about the 20th century, but it's a mistake to think of this part of my discussion as a 20th century phenomenon. Laws migration is an article I wrote. Migratory birds are apt here. People, birds, we all migrate a lot. The borders are permeable, and there's a great deal of movement. And just to go back historically, the U.S. Constitutional Due Process Clause, it borrows words from England and France and state constitutions. Our great equality movements of the 19th century, abolition and women's rights, coming midstream in a transnational set of activities in which localities play important roles. As an empirical matter, foreign law has had a major impact on American constitutional text and constitutional law through various channels, both judicial and elected. And then over time, the origins blur. And so over time, we come to say our, but we should think about our the same way we might think about cars made in America. Not all the parts are manufactured here. Proposition 6, opposition to foreign influences, like those foreign influences, are also long-standing. And I just wanted to flag, and so I put on your next page, I think it is, this exclusive sovereigntism, again, already mentioned this morning. It's nice that I'm fitting inside the stream of our conversation over the day, is Senator John Bricker. Senator John Bricker waved Missouri versus Holland as a flag and rallying the troops to say, right after the UN has come into being, don't let any of that foreign stuff influence us. He wants a constitutional amendment. It's extremely popular. Anxiety is high that the UN will undo America's race relationships as they then stood, and he loses in the Senate by 1 vote. Move forward in time to 2004, his claims remain vital in the electoral conversations that happen as we watch proposals that say don't cite foreign law. The proposed Constitutional Restoration Act of 2004, federal judges don't cite any law that doesn't come from the United States. Of course, I've already said, oops, so watch out, the Due Process Clause has some of those foreign influences inside it. And not all of this is proposed, and not all of this loses. Look at 2006. The Military Commissions Act actually is a piece of federal statute that says federal judges, when you're thinking about how to understand Geneva, the Geneva Convention, no foreign or international source shall supply a rule for decision. Proposition 7. So what I've just shown you are examples of sovereigntism in the United States, which I would call isolationist or exclusionary. That's the topic, that's the heading at the top of that page. And it might be easy for some of us to criticize them as seeming to be hostile to influences from outside and in some sense potentially narrowing. What I want you to, first of all, understand is that inside the idea of sovereigntism isn't not necessarily isolationism or exclusionism. And so I brought you to South Africa for a minute, which is at the bottom of page 5, to show you that South Africa also is sovereigntist. It says we, as a matter of our Constitution, want to put our judges straight forward as speakers of the meaning of what it means to be South African. What does it mean to be South African now? It means to be part of the community of nations. What do you have to do to do that? When you're thinking and interpreting our Constitution, you must consider international law, non-local law, as you decide what our law would be. My point is that inside sovereigntism could be isolationist, but you could be using your judges, instructing them. The proposal in the United States is instruct our judges what to say. The text of the Constitution of South Africa also instructs their judges what to say. Everybody agrees what judges say really matters. And in that, I think, is an important lesson that sovereigntism should be something that we who care about the rule of law should really appreciate. People's identity through law, saying, I care a lot what my judges say, what my legislators say, what our sources of law are, and what our law is terrific, is good, because we battles and meaning to come out of is, and the idea that we find it constraining, authorizing, is something to be admired. One can disagree with strands. The idea that nation's identity regime is something that I appreciate a great deal. The fifth point, which is to relate power and the conversation, is been an effort much of the conversation has that you're talking treaty power, you're talking state, you're talking, although some people have said, the states might or might not. It's not understand when what things you want to call. You only want to call things by the Senate, understanding convergences and about how to watch it, or how you're only looking at the might be missing some for cabin. Now, what I've gone through is normative, basically a good deal of what we're rooted in and last United States important and that makes something as only happening at the local or only happening at the international level. And also I've tried to undermine the notion that there's an obvious relationship between political democratic iterations and something that's either national or local or international. What I want to do now is switch a little bit to talk about what is new in the 20th and 21st century, rather than what is continuous. So for the second part of this piece, of this talk, I want to focus on something I just mentioned kind of en passant, which was that a group of mayors, like 700 of them, have all signed on to something together. And what I just described, and this gets you to the top of page 6, are trans-local organizations. And if you look at the top of page 6 and just run your eye up and down the names of them and the dates, what you'll basically see is we're talking the 20th century. And over the course of the 20th century, groups like the National League of Cities, the National Conference of State Legislatures, the National Government Association, mayors and the like, come, and conferences of judges as well, come into being. And as their name suggests, they are generally organized not by an interest such as climate control or women's rights, but by the political units inside the federation in which they sit, federal, state, city, county, or the kind of office, governor, attorney general, legislator, mayor, or judge. They mirror America's tiered federalism, and they sit somewhere in between an NGO and a governmental agency because they're voluntary organizations of governmental officials supported by a mixture of public and private funds. These governmental interest groups are formed during the 20th century, first to protect the local from the growing national power of the United States government, and at the sub-level, they actually, as some of the cities are coming together to protect and form communities of collective interest to avoid getting special legislation going to one city within a state. So they're formed in reaction to a large national power, and over time, they grow, and they forge links at a level that, again, as someone adverted to this morning, it is beyond the national government to control, supervise, or even monitor. Now, a good deal of this work is aimed at trade and tourism, but over time, as one recent study of state legislatures, of legislation pending in state legislatures has just shown, these political scientists call their article "Taking on the World," because they map hundreds of bills around the United States local legislatures around globalization, trade, immigration, climate control, human rights, and a whole bunch else. A lot of those bills come because of the networks of this group of organizations, which are bipartisan and which function as information brokers, in which they are both clearinghouses for ideas and information and proposed bills, and generate norms for office holders and help to shape policy preferences. For example, the National Association of Attorney Generals has, as of the 1990s, more than 100 policies on antitrust, civil rights, consumer protection, environment, total, more than 100 policy positions. These groups model norms of pooling resources, of entrepreneurialism, of cooperation, and of the devotion of delivery of local services to local constituencies. And, as I've already shown, they are both advocates and lobbyists, and they are conduits for borders crossing state to state, state to federal, and internationally. Some of them generate programmatic obligations, and they're starting to catch the attention of the political science community. They're starting to model things with things like bottom-up federalism and snowballs, where you can get policies going, or taking the pressure off so you get a local policy that the state doesn't enact policy. There's lots of kind of examples of how actually they might work and what the factors are. This set of examples I've given you are U.S. examples, but the phenomenon is not a U.S. phenomenon. Trans-local organizations are occurring all over the world, and they too are forming alliances, and some of them are forming alliances city to city around the world, and on particular issues. And when we talked about global climate control, there are several examples that given already this morning in which you will have Manitoba and Missouri making these arrangements as well. What's really interesting about these organizations inside the U.S.
is they're national, but they're not federal. So they offer us a third category here for our conversation. They are deeply federalist, for those of us among us who are federalists, in the sense that they're actually artifacts of U.S.-style federalism. They obtain their identity and their import from the fact of federalism, and they're really present in U.S. law. They're lobbying in Congress, they're affecting bills, like there are a bunch of them we can talk about. They are regularly participants in courts, being sued, or amici, plaintiffs, defendants, and they disseminate policies that get sued upon as well. They require, therefore, reconsideration of some of the predicates of federalism that many of us grew up believing. A focus on transnationalism requires us to rethink the presumption that we look at states as single, isolated actors, always to be treated on equal footings, sometimes in competition with each other. Lots of discussion of races to the bottom. Now with climate control, we've got races up to the top. Much less in discussion, we had some nice little bits of it here this morning, but much less in general discussion are the many joint actions taken by states, either through the formal compact clause of the Constitution, or much more often through coordinated action, much of which is executive order, informal administrative, informal, just a bunch of officials doing something together with funny, and coming out of courts, you get something like, you get Vermont and Oklahoma, you get 4 courts with a court order that wraps all these cases together in some ways as well. In the U.S. story of federalism, we talk about horizontal federalism, basically meaning state-to-state interaction. And a lot of people say, oh yes, that's full faith and credit. We talk about vertical federalism, and we often say U.S. government told one state. Dan Farber just at an environmental conference on Monday on environmentalism and federalism, and he suggested that we start using the word diagonal federalism to try to capture some of these new strands that are going on. What they make us think about these trans-local actions requires to reappraise the propriety of always conceiving of states as singular actors, rather than seeing them as a collective national force, as responding to their own interdependencies and formulating more of them. They are clearly ports of entry. They clearly are a major mechanism by which the foreign is domesticated. An easy example comes from the National League of Cities, which, if you live inside of the federal court's jurisprudence, it's our shorthand. It's our shorthand for the 10th Amendment. Remember, the National League of Cities tried to say, we get an exemption from federal labor and hour wages, which could have been described as either a conservative or an anti-union or an anti-regulatory position, saying local autonomy for tax dollars. Well, the National League of Cities is also an important voice in local global networks. Starting in the 1950s, in part to combat communism, the National League of Cities got active in sister city programs, people-to-people diplomacy. The bottom of page 6, I'm here in Missouri, so I gave you an example of about a dozen cities here in Missouri that have relationships with some 22 countries, China, Ecuador, Germany, Japan, and the like. And what you see in Missouri is replicated around the world. 126 countries are linked with more than 250 communities, 2,500 communities worldwide. Now the National League of Cities is itself linking with something called the United Cities and Local Government Organization, saying we're the human rights workers dealing with the UN, and their initiatives include housing, education, inclusiveness, respect for diverse cultures, inequalities in our cities, i.e., National League of Cities, once identified as having a kind of anti-regulatory agenda, is now got a human rights profile. In there is a lesson that these organizations are not intrinsically one thing or another. They may be simultaneously many things, and their leadership and their issues vary as they try to respond to their constituents. You cannot essentialize some position by looking at the level of government. And thus far, I've given examples that might risk us thinking that if it's local, it could be, quote, progressive in some way. But please, as you know from Professor McGinnis and others' work on Briard and the role of death penalty, states and localities can be more corridors that are warding off or welcoming in different kinds of transnational precepts, from the death penalty to anti-smoking, actually, which is a big issue that we've been somewhat of an exporter in. I live in New Haven, which is currently identified as a sanctuary city because of its immigration policies, but I just live in Arizona, which has a famous unit decision upholding extremely restrictive, extremely punitive policies for any employer who employs anyone who is not properly documented. If I move to all the major Supreme Court federalism cases, what you do is you find people in some of these local organizations on both sides of almost all the major cases here. We've thus far in the morning talked a fair amount about whether the U.S. should be affiliated with transnational efforts. And the presumption has basically been that for those people who are eager for the U.S. to have some more progressive agendas of which CEDAW and climate control are typically identified, it would be really good for the United States to be a part of this. I want to pause to have us think about an import and export and ask the question not only from the perspective of the United States, but also from the perspective of elsewhere. Which is to say, that the sort of assumption is, gee, the U.S. should sign CEDAW, and that will be good for everybody. I don't know. Maybe if the U.S. signs CEDAW, the U.S. will try to export to CEDAW some of its views of equality, which in some instances are narrower than that espoused by the Convention to Eliminate All Forms of Discrimination Against Women. Senator Biden says, let's get the U.S. involved in international violence programs. Well, it depends on what the U.S. position will be as to what the tenor of those programs are on our trafficking work, which is extremely punitive rather than generative in a variety of ways. And moreover, Senator Biden is currently focused on an International Violence Against Women Act on an exclusive set of on a role that is exclusive for the national government and not building any roles for states and localities as well. So when we think about the American Federalist organization, we might think about it as a rich opportunity set in which we can think of many different ways in which these relationships could occur. And for those of us who have substantive agendas about how we want to change either U.S. law or international law, we should be constantly reminded that we have to think about what the substantive position is rather than assume that going international brings or bringing in the international necessarily brings a particular set of principles or the like. What I've also argued now, in part one and part two, is that transnationalism has a long history in the United States, that it's basically unstoppable, and that on many metrics it's also politically legitimate. But that doesn't exhaust the questions about it. So the last segment of my comments I'm going to ask and look at, is it legal under U.S. constitutional provisions? Ought it to be, is it good for federalism or bad for federalism? How might we think about this phenomenon that exists? So let's first start inside the United States and think about the federalist structure of the Constitution. And on that measure, what I want to do is praise trans-local organizations because they embody federalist political commitments to redundancy and multiple levels of authority, undermining the centralization of power. They amplify state and local voices through networks, and they denote the importance of the role of states and localities in generating the national norms. In that sense, they are really in service of a nation committed to a federalist system. They can form and be very bring those points of view to the nation. And they can create both loops. They can both inform national policy and be feedback loops for how it works, as well as implementing national policy or seeking to refine it. So in short, on a variety of different metrics, including an argument from the structure of the Constitution, but not, of course, its text, its text, by the way, to the textualists here, the word federalism is actually not in its text. So as we move beyond its text to the structure, I can make arguments for how national organizations of localities are deeply federalist. And for those of us who are rational choice economic actors here, I can say I might be able to show you ways in which they're efficient. I'm sure there might be inefficiencies as well. I can also actually show you ways in which we might hesitate a little bit. Because one of the ideas in federalism is we want a multiplicity of policies. We want diversity. And the easy example is the Uniform Commission on National Laws. Some of this transnationalism, translocalism, damps down diversity and is another engine for uniformity. And for those people who are trying to promote different outcomes, this gets a little in the way, or if we think about it as a rational choice person, it might be that they're starting to signal to us the inefficiency of variation, at least in some areas. Now, if you move from those kinds of concerns to what might be called political theory, we get a bump in the road. We don't really have a word by which to call these organizations. NGO, non-governmental, GO, governmental. The social movement literature talks a lot about networks of advocates, transnational advocacy networks, TANs, spawned by NGOs, and then working with government. And in the political science literature, some of this is talked about as intergovernmental lobbies. Well, these are groups that are voluntary affiliation. They get their political capital and their social capital by taking their name in their government position and recycling it in their voluntary private organization. They're a mixture. They really have attractive features because we live in a world that doesn't have much good governance and not enough people being public civil servants, underpaid as you are. So we want there to be these organizations, and maybe we should be subsidizing them more. But there are questions about transparency and accountability and policy making, both internal in terms of their own representative structure and external, because their voice is a collective voice that says, here we are males, here we are. So we have to actually, we collectively a little bit, undermined in either the empirical or the political theoretical literature are how these organizations work. There's a group that is saying, oh, they're bad cartels, and somebody else is saying, oh, they're the best thing since sliced bread. I think there's a fair amount of work to be done as we think about bonding and monitoring, like any form of aggregate class action literature or anywhere, what's this representative structure and how might we make them? So there are regulatory questions that are there, or subsidy questions that are there. It could be both sides of this. There's a media question that's on the screen that is the one I'm going to come to conclusion with, and that's the question about regulating their output through the word preemption. And we'll get us back to the foreign affairs, dormant, implied, commerce, non-commerce, all the powers that are stated in our Constitution where we sat this morning, and Missouri versus Holland. Now, Missouri versus Holland Missouri said, the federal government is disabled, has no constitutional power to touch migratory birds. So they go to the courts to say, stop the feds, right? What we're watching today is mostly groups of manufacturers go into the courts to say, stop the locals. And the example I gave you, which comes on the next page of this handout, involves the current litigation about divestment in Darfur. Illinois, like many other states around the United States, and many people in the United States, horrified at genocide. Rhode Island's Secretary of the Treasury says, not on my dime, not on my, their slogans, not on my dollar, which is to say, I don't want to do business with any company that is doing business in Darfur because that is enabling and not stopping genocide now. And so, many cities and states have divested through advocacy networks, some of which are governmental and some of which are non-governmental organizations. The same group that went in to stop Massachusetts from taking its
for not spending any money on forced labor workshops in Burma, went to federal court just a few months ago and got a judgment that stopped Illinois from its divestiture program. And what you have is what some of us will call the implied dormant foreign affairs preemption, which is implied and dormant because I don't have a text. I've actually given you the form in the words of the U.S. Constitution right under that to be very clear that if you want to say that the power over Illinois' spending of Illinois tax dollars is outside the power of Illinois when it's buying and selling things that have international implications, you're going to have to say something about implied, because you can't actually say it too easily from the text. And you're seeing that a lot of judges are, in fact, implying this. And what you're seeing, therefore, and preemption is now a hot topic with, 12 law review articles and 2 books kind of on the screen. For those of you who are teachers and for those of you who are students, it's really hard and boring to teach preemption, because in theory it's an incredibly focused question. Does this statute preempt that activity in a very narrow way? But lo and behold, if you put a bunch of preemption cases together, you have a grander theory, which is basically locals has got to stop. You can't do this. National preemption is we're watching the snowballing effect, if you will, of national preemption, and we're watching a fair number of federal judges, including some on the United States Supreme Court and 2 major U.S. Supreme Court decisions in which the United States Supreme Court says local action is precluded. Now, you can imagine from my rejection of categorical federalism that I am not a fan of the assumption that you can't have concurrency here. And as far as if I'm writing a constitutional interpretive text at this point, I would suggest that the judicial extrapolation from the Constitution of this major preclusive national executive agency or State Department or set of preemption is way overblown and does, in fact, thank you, Missouri, step on the toes of many states and localities as a matter of federalism. I would actually push to have a clear statement rule akin to that which we say with Congress. You want to limit state sovereignty on the 11th Amendment, you better say so loud and clear. I'd have the same burden on Congress for foreign affairs preemption. And in that sense, akin to Herbert Wexler, I'm here saying something about the political safeguards of federalism, but I'm actually saying something about the translocal safeguards of federalism. And what I can show in terms of the translocal safeguards of federalism is that, in fact, after that federal judge preempted Illinois, a whole bunch of people went to Congress, Dick Durbin taking the lead, Senator Durbin, and the Sudan Accountability and Divestment Act of 2007, this is December 31st of last year, now exists. And it's a very interesting piece of legislation. I've given you a bunch of it because it actually puts everybody on the screen. It says there's really not going to be federal preemption as long as the businesses have notice and an opportunity to be heard. You're divesting from the right people. Secretary of SEC has a little role, Treasury has a little role, the businesses have some role, the federal government can certify, the president is on the screen, he can waive the contracting divestiture procedures and the like. So it's a bill that actually puts in play all of the relevant players. The last piece of your handout is the presidential signing statement, and we come full circle. The president says he's got exclusive authority to conduct foreign relations. I didn't give you, but actually after this is passed, the National Conference of State Legislatures says, hey, Congress, you didn't do well enough by us. You've given us a lot of burden to prove all of people, to get the right to divestiture. It's too hard for us. And the National Foreign Trade Council kind of likes this bill because it's pretty hard, although it also says it may not be constitutional. We promise to litigate some more, too. So we're really quite in medias res. So let me conclude by summarizing this interaction between internationalism, sovereigntism, federalism, and localism. First, as we enter the new century, the relevant participants in the policy debates extend on the public side beyond the 3 branches of the national government and the states acting either solo or coordinated through Congress. Translocal organizations like the NLC, the Conference of Mayors and the like, collective actions of state attorney generals, are important parts of national players rooted in the states, yet reaching across them. Laws, and they are both currents for law from abroad and currents for law from within, and the new technologies have made it all the easier to do their work. Second, while I really do appreciate sovereigntist impulses, and I agree with the idea that we want national identity through law, and I appreciate the costs of fragmentation, which are non-trivial, there's no avoiding these multiple and interacting legal regimes. Third, for those of us who are federalists, these multiple regimes fit within a constitutional vision, if not their text. And for those of us beyond federalism who just think it's a good idea to have lots of people trying to deal with the incredibly difficult problems that we face, how to deal with liberty, equality, dignity, how to deal with the environment, what regulation, having more players in the mix could be helpful in some sense that we need all of the resources and ideas we can get. Fourth, to be enthusiastic about these multiple layers of decision-making is not to presume that decisions coming from any one level of them will necessarily be wise or good or just, but rather to appreciate that in a democracy, it's the conflict among them that we have to tolerate and indeed celebrate. It's conflict that we have to deal with, not just a notion of multiplicity. And there'll be some ramming down and trumping in conflict resolution. Fifth, we are actually watching a surge in sovereigntism. The effort for the president in the Sudan and in many other areas to insist on the centrality and the unilateral authority of the nation state. And as much as you want to try to insist on this category, the world makes it impossible. And it's the mayors acting on the problems of the local, as well as the people all over the rest of the world, who make these distinctions unstable. Commerce, manufacturing, direct and indirect, police powers, foreign, domestic, none of these categories are going to hold. The claim of a sovereign center equated with national government and exclusive authority to deliver and organize goods and services and security simply will not be, cannot be sustained in the world in which we live. Now, one might be tempted, therefore, to say, for William Butler Yeats, the center cannot hold, but actually one needs to be reminded in a Federalist vision that the point, of course, is that the center should not hold. It should not contain or constrain all policy and principle. And so now come back one last time to Missouri versus Holland. Holmes, therefore, said preclusion. I'm, of course, saying concurrency wherever possible, but weren't we lucky to have a case with this name? Now, the Holland there was actually Ray Holland, the U.S. game warden. But if we think about it as Missouri and Holland, as in the nation of the Netherlands, and many more, we have in it a little shorthand for the current world in which we live, in which we all have to figure out ways to co-venture, as well as to figure out when we want to claim something as our law, and proudly proclaim it, if not made 100% of the USA, as a tag of the USA. Thank you. Many of the people here know much more than I about these various threads. I'd be welcoming additions or comments.
I thought Mike was maybe
We have the beginning.
Well, I thought I was going to disagree with one of my two, actually. I think I actually...
He's going to disagree with
that. What struck me at the outset was the tension that you set up between sovereigntists and federalists. And as someone who's been called a sovereigntist in print, including by some people in this room, and also as someone who's worked a lot on behalf of federalism, including some of the controversies that we've talked about. which I would regard as simply someone who wants to see domestic processes, domestic democratic lawmaking processes be given their full scope. I don't see a tension between that and the kind of localism and trans-localism that you're urging. In fact, I see that they reinforce each other. And perhaps that just means that some of the people who are floating themselves in sovereignist rhetoric are not real sovereignists. But it also seems to me that perhaps there's a little tension in what you're advocating, in the sense that that a true appeal to localism will reject some of the attempts to use international law and international processes to circumvent local democratic decision-making. So I guess that's the question is it really a tension between sovereigntists and federalists, or is it in fact a tension between federalists on one hand and nationalists and internationalists on the other?
So I want to disaggregate some. There's a descriptive claim, first of all. The argument against CEDAW is couched as a federalist argument, and in some of our questions about whether we're going to sign on to some things, it says, in the name of our federal structure, we cannot do that. The federalist reservations, if you will, to some international conventions. And in the context of fighting some of the international, some people say, I'm a sovereigntist, respectful and mindful of federalism, and that means we oughtn't to be international. And my conclusion, and perhaps yours, is we can watch within a federation the international coming in through the federalist structure. So we want to tell those people who are standing up saying, my sovereigntism comes from my federalism, or my sovereigntism comes from my majoritarianism. You may be a sovereigntist, but we have to evaluate that claim in isolation, if you will. Second, of course, I'm trying to show that sovereigntism isn't, I think we probably agree, isn't a unitary phenomenon. In addition to being exclusive, you can have different arguments for it, or different justifications for it, or different claims for what would make something politically legitimate within your particular sovereignty. Then this question about how we think about the thing called the international. My basic argument is it isn't a thing. There are a whole bunch of social policies and people devising ways to live on the planet as we now find it. And they're looking in many different places where law is made to try to cope. And they're going to look, if Sweden figured out something, let's use something from Sweden, because I got to stop people being sick from lead paint or whatnot. And so the world in which they're inhabiting is not tracking the territory that once seemed to be so instructive. There's a guy who was the ambassador of the European Union named Jean-Luc Guéhenno, who wrote a book called, which in English is translated as The End of the Nation State, who basically said there was a period of time in which territoriality actually captures a fair amount of how people use human resources. Basically, it's an economic model, a good deal, of how people use human resources as well as security. It's gone. And local things matter a great deal, and then the nation state cannot provide the kinds of services it once did. Now, the answer is, what do we do now? And one answer is we try to refigure out how to have the nation state provide better services, which could be a great deal of dependence on both the local and the global as well. So I think we are clearly overlapping and ideally interrupting the conversation that tends to put people into boxes and then act as if those boxes themselves gave you an answer in particular arenas.
David Slauson and Swain.
So we're on a run.
I want to push you a little bit to sort of look at this from a constitutional standpoint. So on the one hand, you're sort of celebrating multiple layers of decision making, which I'm very sympathetic to. You're also sort of critiquing the idea, sort of what you call an essentialist idea, that something is essentially local or something is essentially national. So does it follow from that then that there's really no role here for the courts to sort of strike down a law saying, you the local have intruded on the national, or you the national have intruded on the local, because there's nothing, there's nothing for them to base that on.
Well, part of it will depend on your attitude toward what judges are and how much they should do. If you believe that judges should generally, coming back to our political safeguards, not be energetically looking to strike down enactments unless there is a violation that compels them to do so, you ask them to embroider doctrine less. And therefore, when someone says, excuse me, whether or not insurance companies have to divulge information about their holdings and assets anywhere is something that is exclusively for the national. For me, I'd have to put a great burden of persuasion on why, at this moment in time, it is a problem to have California say to the insurance companies, tell us whether you had Holocaust assets or not. So one is a much greater facticity. I make judges work harder rather than just say, oh, foreign, oh my goodness, foreign, and ask them exactly, and I make the executive branch, which by the way, in some of our famous foreign affairs implied preemption, took the position that it was just fine for the court to let the local do something. So it's the kind of almost irony for those, is that it's been judges who've had their hearts beat fast in the face of the potential for something that could create a bump in the road, and it's often been the State Department, or either who hasn't wanted to say something, or I mean, maybe they really did want to say something, but they haven't said, sometimes, you absolutely must stop this local behavior because it's going to upend. And so if you take the Burma case that I know Ned and a bunch of us, Crosby, the case in which Massachusetts says we don't want to spend tax dollars on those sweatshops, exactly how much national harm do I have to show? What form of intervention? What enactment? So I would put the burden hard on Congress to say this is actually not tolerable. And that's where the Sudan Accountability Divestment Act gets interesting, because Congress, I think, says if you do it the right way, you're not preempted. There's actually a constitutional question in that. If you believe that foreign affairs preemption comes from the Constitution text expanded by the judges, then Congress doesn't have the power to overrule that preemption. I'm saying, judges, you made it up as federal common law, and yes, Congress does have the power to tell us that we don't need a single divestiture activity, and indeed these multiple divestiture activities might be very useful. I know that you've actually written a lot about this, so you can add on.
No, I mean, I was very impressed by the speech, and I agree with it almost all the way, except in a couple of regards. One, I'm on board with you resisting the essentialism of the board. One of the things that remains somewhat attractive to me, though, is what you probably would rightly call essentialism of the international or the interstate. The sense that somehow, even if we can't define what is truly a matter of domestic or foreign concern, we might still try to regard somewhat differently relations between some U.S. governmental entity and some foreign state. And one of the things that leads me to be somewhat attracted to this is it's not just a U.S. preoccupation. For example, there's a fair number of regionalism movements in Europe that do seem to allow inter-regional cooperation or interlocal cooperation without giving the same degree of sanction to local foreign state relations. And one of the productive, but probably accidental, features of that is that it tends to encourage the blossoming of the regional and the local, to encourage a different channel of communications as opposed to having your local municipality, Chicago, say, sign an agreement with Germany. It tends to encourage agreements between Chicago and the lender or something like that. The second point is the dialogic aspect of this. I mean, I'm quite enthusiastic about this Vienna result, actually, because it seems to me here, up until the sign statement, which I thought was focused, you have state and local divestment followed by judicial intervention, followed by a congressional safe harbor, and a fairly informative process. There may be national costs attending these state and local initiatives. Congress has been asked the question directly, has opined, and said in most circumstances there will not be.
So long as you follow these rules, you're not interfering with what we regard as a national interest. I agree with you that there remains the question of this technical preemption question, but we suffer that in other preemption courts as well. And so, to me, one of the happy accidents, I guess, of the federal system is this happy outcome. And I'm wondering if you resist this as a method of developing national and local policy, because I would embrace it.
No, let me go back and come. I put out this Sudan Divestment Act as a terrific example of the translocal safeguards of federalism, because what you get is a bill that's worked out that has different people in sight, and so this idea that it exists doesn't mean it can't be regulated, and congressional regulation may well be to be invited. So I think of this as dialogic, democratic iterations, and this actually is partially an answer to the idea we should never think of courts. I actually think we should never think of courts as conversation stoppers. That if you live in the United States and have watched, whether it's Plessy to Brown or Roe to Carhart or pick whatever topic you want, we're in the middle of a conversation all the time, and courts are a piece of the story, but even when it's constitutional bedrock, it looks like it's a little less bedrock than it was last week. So Commerce Clause, wherever you want to go. Most of anything that is hard and feels hard over time means that there's movement, and courts are part of the movement, and indeed courts can be a mechanism for making it visible and being a spur to democratic processes rather than an interference with. Roe has created an amazing amount of politics, or has been used to create amazing amounts of politics, either way you want to put it. So I think this Divestment Act is a great example of a good way to deal with how to take into account a bunch of different players, whether it's optional or not, I don't know. In terms of the notion of the attraction, of course, subnational gets you to duck the constitutional problem, because the genre of law that it is and the genre of agreement that it is doesn't get you to this problem of the nation and who can speak for the nation. I want and we know that Missouri and Manitoba, or California and England, Tony Blair and Arnold Schwarzenegger, shake hands and take a photo op and talk about energy policy together. What I think the nation-to-nation misses, at least in the size of nations like the United States and maybe everywhere, is the degree of dependence on the local to implement whatever these national obligations are, which was the last panel's discussion. And as a consequence, we maybe want to revisit how to structure these national arrangements to build in more of an express role for the local, not just in the formal sequencing of when are we going to have a national legislation to implement the treaty. And in a way, that's why I've put so much of the International Violence Against Women Act out, because I've written to Biden saying, why aren't you putting in some role for localities? Why are you only centralizing it in the nation at our level or other levels? Let's start looking at these subnational arrangements and seeing that in them is education of how people provide services. And I suppose if I were leaning toward a little bit of essentialism, it's that people who are elected to run localities have to actually have electricity in the streets. And that degree of need to provide social services, which makes me particularly affectionate for state courts, which after all have to be responsive to the needs and describe themselves much more with all due respect on the federal court system as needing to be responsive to the citizens for whom they work. And therefore maybe a less attractive part of life tenure is this idea of pushing yourself away, and if we use that kind of structure as an analog, the national can get far enough away that it doesn't really have to think about how to deliver on that which it says. And it's this delivery part that we see the utility of the subnational.
Two more questions, Paul, Stephen, and Paul Berman.
Wonderful speech. I'm trying to think beyond it, and one of the things that occurs to me is that, just use good Marxist terminology, objectively the conditions of the alignment of political power and territory are breaking down for important material reasons. And we have to think about new forms of governance. If we move beyond the formal structures that we're familiar with, one of the things I worry about is the rise of the corporatist alternative. And some of the things you talk about suggest that. You know, the idea that we have an organization that represents people who are defined as being part of this group, and that real political power is shared with groups like that. And I wonder, does that worry you as well?
Well, one of the reasons to bring to the fore these translocal groups is to try to think about transparency and accountability, and at least ask them to interrogate internally when they stand for the National Governors Association. Actually, the good example is the National Association of Attorneys General. There's a split up called the Republican Association of Attorneys General because they disagree about what it is that they should say. I want them to be able to coordinate and cooperate, and I take it I also want them to be able to weigh in if they have a collective view on what good welfare policy or unfunded mandates or antitrust policy is. But I actually need to know how they got to that view and how many people what states they speak, for whom they speak. So I have a slight impulse to regulate, to require clearly at least disclosure, which they tend to do in various of their materials, as to what the position is and how they arrive at it. Many of these organizations, as far as I currently understand them, have a good deal of revolving leadership that moves, that makes it hard to have deeply entrenched political wings. And when the Republican governors broke off, the Governors Association in the welfare policy ended up having less Washington-based clout. So we also need to understand these organizations in relationship to other such organizations. So they're in conversations with the national. They're going to get authority by being persuasive to the national. The more they become partisan within, the potential they'll lose some of their political capital as representing a broad sweep of political policy. So they're going to be kind of regulatory pressures that are intrinsic to their material conditions, if you will. If we were to, the need to have, I guess the other example is the National Foreign Trade Council, which is a major voice for knocking out these policies. So I can go on their website and learn a little bit about them, but I maybe need to learn more about them as I watch this repeat play of phenomenon gather energy and steam. And I have both a regulatory question and a subsidy question. Right? I might want to regulate them, but I also might want to subsidize them if I think they are positive contributors to the governance on the public side. And at least in terms of these organizations so far, my sense is that we net out positively, even when they bring cases I don't like, because they create this democratic iterative process. I think I know I'm just starting to understand, try to think through the implications of these many organizations, some of which are only like 30 years old, in terms of what they're doing and how they work with each other and how much I want them to be lobbyists and what kind and what issues. It looks like they get their most clout by being lobbyists for something called the public good of their citizen, of the position they hold, which has attraction in a world that seems deeply issue specific. So that's one of their great appeals, is they make it across the issue envelope that we're currently watching people get locked in.
Question, Paul?
So, as you know, I'm extraordinarily sympathetic with your general project. I have a couple of questions that I wanted to ask. The first one goes to this sort of the location of these democratic iterations, and it goes to the Darfur question to some degree. I totally agree that courts are not the end of the conversation and are often the spurs to democratic conversation. And in this case, bore out, and you sort of see that as a model. Ironically, that only works if the court first tries to cut off the conversation through the application of the foreign affairs preemption. That's what gets the national legislation in response, at least as you told the story. And so I wonder if courts saw themselves as, in the way that you want, as not, cutting off the iteration, that they might have the effect of sort of co-opting the discussion so that all happens within courts as opposed to this sort of back and forth in different places and in different sort of governmental locations. So, you know, what would have happened in this case if courts had not asserted a strong foreign affairs preemption? Maybe you wouldn't have had as good a dialogue as you now have.
I had the good fortune of spending Monday at a conference on environmentalism and federalism, where the vice president of one of the major, or the general counsel of one of the major automobile manufacturers was complaining quite bitterly about California's emission policy. And in that comes the answer that whether he's lost so far in the courts, he hasn't gotten preemption, but he, in his corporatist hat, has an economic stake that informs him, at least at the moment, that he needs uniform policy. To the extent he needs uniform policy, he's playing national. And I mean, actually, genuinely, it's not clear to me in the long-term interests of these motor companies that they may actually have a long-term interest in getting some variation, because not for the national policy will be optimal for their economic interests, let alone anything else. But he was pretty clear that uniformity and predictability and a national rule as far as he can go. So even if the courts drop out, he's going to fight with California to go to Congress to get a rule. So I think the courts are a piece of the story, and I imagine people will try to listen to marketing litigation is remarkably tone deaf sometimes to what one might think would be, you know, inefficient litigation. So I imagine people will knock on various doors and, with maybe the breadth of judges, get some answers in all these different directions. It looks like we have no dearth of interest groups funded to push their policy, which is again why I get attracted to interest groups whose interest claims to be citizenship-based or social or public government service-based. And how we can figure out how that's pure and how we can make them engines for as rich a diversity of people as they have, I don't know the answer to. But I think it's not going to be a conference. I don't think that we need the courts as energetically preemptive as they are to get what we
generate backlash. Right?
Yeah. We have other forces for lash and back.
The second question quickly is just that all of your examples, although, as you say, they're not quite governments, these sort of transnational networks, they do tend to be official state actors in some form or another. And I wonder where in your framework you would place non-state norm-generating communities of various sorts, who obviously also are pursuing things, sometimes internationally, networks of bankers, as we heard earlier, or other non-governmental organizations, and so forth. How do they fit into your scheme? And why are they sort of not part of the story as you tell it right now?
Because you don't need them. You don't need me for that. You've got a million people writing social movement theory around both conservative and liberal NGOs. And what seems to me kind of interesting in that literature is missing this stratum of mixed groups, which are both governmental and in some sense voluntary association. I kind of actually got into it in some sense because I worry a lot about the Judicial Conference of the United States speaking on behalf of Article 3 judges, telling Congress not to pass the Violence Against Women Act, Civil Rights Remedy, or some other things, and start thinking about how public officers use their platform for what. And while I find some of the judge stuff unattractive, I find some of the electoral stuff much more attractive in the sense of properly advising without raising problems of impartiality and why should you care who before you want what cause of action. These mayors and they're all saying, I need this to run my city, I need this to run my town. They may be saying I need less welfare. Let me be clear. This isn't a romance of the local in terms of my own particular policy preferences. Because they may be saying, I don't want immigrants and I don't want welfare. But they are trying to say something about what it means to make a city or state work. And they're spending a lot of time and energy, it looks like, for making our lives a little better, and we have too few of those actors in our system.
Thank you so much.